This morning, the Trump administration is facing more fallout from their handling of the Jeffrey Epstein case. Calls growing louder within Congress, for one, for Ghislaine Maxwell, the longtime Epstein associate who was convicted of child sex trafficking offenses related to the investigation, calling for her to testify about what she knows. Conversation now around that. And now attorney Alan Dershowitz, who was once an attorney for Jeffrey Epstein, says that he believes Maxwell would be willing to testify before Congress if given use immunity.
She knows everything. She is the Rosetta Stone. She knows everything. She arranged every single trip with everybody. She knows everything. And if she were just given use immunity, she could be compelled to testify. I'm told that she actually would be willing to testify, and there'd be no reason for her to withhold any information.
Adding to the spectacle now, after that, a source close to Maxwell told CNN that she has not had any discussions about testifying before Congress, and also that Alan Dershowitz has had no contact with her. Joining us right now is CNN senior legal analyst Elie Honig for much more on this. Let's start with this piece, and then I want to ask you more about what could be released with all these calls of having more of the investigation released. You are skeptical that Maxwell would agree to testify before Congress. Why?
Yeah, I'm extremely skeptical, Kate, despite whatever Professor Dershowitz says. So first of all, if Ghislaine Maxwell was willing to come clean and testify truthfully, why would she not have done that at any point in the last 4+ years while her prosecution was ongoing? Because had she tried to testify and cooperate at any point during that time, she would have been in position potentially to help herself. Instead, she refused to talk. She went to trial. She got convicted. She got sentenced to 20 years, and she has made no indication of willingness to talk. Also, keep in mind, part of the initial indictment against Ghislaine Maxwell points out that she lied under oath. She was deposed under oath in a civil case, and she outright denied knowing anything about Jeffrey Epstein trafficking minors or her own involvement in trafficking minors. So she's not exactly a bastion of credibility, and I am not going to hold my breath for the day where she takes an oath and testifies truthfully in front of Congress.
I want to read for everyone the full quote from this source close to Ghislaine Maxwell, kind of it seems like batting this down. Here's the quote. While Dershowitz is brilliant, he does not represent Ms. Maxwell and has had no contact with her. There has been no discussion about her testifying before Congress. Her only counsel of record right now is fighting her case before the Supreme Court. On this, what is use immunity? How much protection would it give her if this whole thing would come together, considering that she's clearly fighting the conviction?
Right. So Professor Dershowitz is sort of thinking ahead to the legal chess game that might hypothetically break out if there was some effort by Congress. The way this would work is Congress would subpoena Ghislaine Maxwell. And again, I'm skeptical any of this is going to happen. But Congress would subpoena Ghislaine Maxwell. She then, if she had any kind of decent lawyer, would take the fifth, because even though she's been convicted of sex trafficking of children, there potentially would be other charges that could be brought against her. She could be charged in the state. She would absolutely have a right to invoke the fifth. The counter move to that is what Professor Dershowitz is talking about, where Congress has the ability to immunize somebody, meaning, okay, we're going to force you to testify, but your testimony is not going to be used against you in any future criminal proceeding. So in theory, that could compel her to testify. But again, I think her response would be, too bad. Like, I'm already doing 20 years. Why would I care about a citation for contempt of Congress? And again, why would anyone think Ghislaine Maxwell is suddenly going to come clean and tell the truth now?
Very important perspective. With this request, though, now from the Justice Department to now release the grand jury testimony in the Epstein investigation, I mean, how long do you think it will be before this is decided? And once it is decided, how long before things would be released if that is what is decided?
Yeah, so the case is now in the hands of Judge Richard Berman, a federal judge in the Southern District of New York. I appeared in front of him many times. He's a good judge. He's down the middle. He works hard to get it right, and I don't think he will let this drag out too long. A couple important things to understand. One, even if this request is granted, even if the judge says, go ahead and unseal grand jury testimony, that is going to be a sliver of the overall file. Could be important, but it will be a narrow sliver of the overall file. The other thing is, if you actually look at the grand jury secrecy rules, there are some exceptions on the books where you can unseal and make public or give to somebody else part of the record. But none of those apply here. Those all basically say if some party in another lawsuit needs them, if there's a defendant who's been charged elsewhere who needs these documents to make a motion to dismiss. And if you look at DOJ's motion that went in on Friday, they acknowledge that. They say basically, Judge, we understand none of these exceptions really apply, but we're kind of asking you for an all-purpose exception because there's such massive public interest here. So I genuinely don't know what Judge Berman's going to do. Neither outcome would surprise me, but the reality is we're going to see little of the file if he does agree to release it and none if he does not.
As the scandal, the fallout continues over the Epstein scandal, Epstein co-conspirator Ghislaine Maxwell could testify in front of a congressional committee. Maxwell, you may recall, was sentenced to 20 years in prison for carrying out a years-long scheme to groom and facilitate the sexual abuse of underage girls. Well, now a former lawyer for Jeffrey Epstein is pushing for her immunity in exchange for testimony.
She is the Rosetta Stone. She knows everything. She arranged every single trip with everybody. She knows everything. And if she were just given use immunity, she could be compelled to testify. And there'd be no reason for her to withhold any information. So I don't see any negative in giving her the kind of use immunity that would compel her to testify.
CNN legal analyst Joey Jackson joining me now. Good to see you, my friend. Practically speaking, should there be some sort of a deal, should she agree to testify here, what more do you anticipate we would learn from Ghislaine Maxwell?
Yeah, Erica, good morning to you. I think this could be extraordinarily significant. The answer to your question is everything. Why do I say that? She's known, certainly, as we see in the pictures there, to be a person who was close to Jeffrey Epstein, to be his girlfriend, to be his enabler, to be whatever it is that people might classify her to be. At the end of the day, though, we know she was there when the deal was made and hand is shook, so to speak. She can tell you the who, what, when, where, how, why, etc. And therefore, I think she would be a wealth of information in the event there was a deal struck and she presented testimony before Congress, Erica.
What about, too, this push for the grand jury testimony and what that would actually reveal, which is far less?
Yes, I think that's a complete farce. It's disingenuous and it's ridiculous, quite frankly. Why do I say all those things? We have to keep in mind that a grand jury sits and they don't determine guilt or innocence. They just determine two things. Number one, whether there's reasonable cause to believe that a crime was committed. And number two, that the subject of that proceeding committed it. There are 23 grand jurors. A simple majority, that is 12, can vote out an indictment. When you're a prosecutor bringing forth a case before the grand jury, as I have, what you do is you just present enough legally sufficient information to give them an indictment. And that means that you give them bare bones. And as we look at that picture there, and that information is specific as to the defendant, you're not being all-inclusive to present information which the public wants to know with respect to who else might have been involved, what were they doing, where were they, how were they. So it will not give you the breadth of information. I think that that's something that's a shiny object, but it's a shiny object that's a distraction, and it's not fair, I don't think, to the American people, particularly, Erica, when the motion saying, hey, release the grand jury minutes talks about transparency. If you want transparency, guess what? There's a file in the Department of Justice, or is there? Because according to the memo, there's not, after they said there was. But if you want transparency, release that document. That'll tell you what needs to be done. It'll tell you who was where, what was why, who was involved, if anyone. And I think that's the information you need. And you could do it in terms of redacting, that is really blacking out information that would be harmful to any potential victim.
You know, to that point, Joey, is there a broader impact that either you are seeing or that you are concerned you may see when it comes to not just the Department of Justice, but frankly, to legal cases moving forward that may have an outcome that people don't like, right? You don't have to like it or agree with it to have it be a finding. I mean, is there a broader impact here based on what we've seen, the back and forth from the Justice Department?
So there always is, Erica, right? I mean, law is based on precedent, and you have to be careful what you do because it sets a precedent for tomorrow, next week, next year, the year after. But at the end of the day, what courts are about is they're about justice, and why you would release information and a file is about that very issue. If you look at the motion, it's predicated on the standard. Why would you release secret information? Because there's a public imperative, because it fits into the interest of justice, because inquiring minds want to know. And in a democracy, this is not about secrets. This is about doing what's fair, what's adequate, what's appropriate. And you have a number of people who are clamoring for information. So, right, to revert back to the point, why not, according to, right, Mr. Dershowitz, give her use immunity? What is use immunity? Use immunity is anything Ms. Maxwell might say before Congress couldn't be used against her. Any information derived from any statement couldn't be used against her. I think that could be certainly something that's compelling. Last point, Eric, and that's this. Of course, she'll be assailed because she's an interested witness. She's doing 20 years. She's appealing before the Supreme Court. But there's an interesting thing in law, Erica. It's called corroboration. So everything she says, if you vet it, right, whatever you say, is there a text message to support it? Is there an email? Is there surveillance? Is there a photo? Is there a document? Are there flight records? All of that stuff. Are there other witnesses? I think information could be vetted such that you could determine if there's a grain of truth. And if there is, let the truth and justice lie where it may.
Joey Jackson, always appreciate it, my friend. Thank you.
Thanks, Erica.